What's up, everybody, and welcome in. I know I've been a little MIA the last couple of days. I've been preparing for my trial, which is probably happening as you are watching this video. But welcome in. I've recorded a few videos this weekend to play throughout the week so that we can still discuss some cases. You can still hear my voice and see my face and interact with me on the interwebs while I am in the courtroom. Doing my day job, sharpening my skills, using everything I've learned in school, in practice, and of course on YouTube from all of you and all the cases we watch together. So I appreciate your support always. I appreciate you coming in here, sharing your opinion, asking your questions, letting me know how jurors think. So I always appreciate that so much. We've got some new lights in here. Let me know if you think the lighting is any better. But as I'm preparing for this trial, it reminds me why we need to give grace and be understanding to the lawyers that do this in the cases we watch. It is very difficult. It takes so much time to prepare. It is so hard to get the whole case in your head. And even when you have it in your head, you always have to be ready for anything during trial. You've got to adapt. You've got to realize things can change on a whim. Witnesses might not show up. They might say something different than you expect. You might have to impeach a witness. And you have to do it all while looking professional and sounding professional in front of a jury that does not know you. They do not know your client. And so it's very important, very stressful, very difficult job. So that's why we will continue to always do our best to give grace and be understanding to the lawyers and judges that do this for a living. Today, we are talking about a case that has not yet gone to trial and some stuff that just continues to stack up as to giving fodder for alleged conspiracy theorists, for people that are really pushing that Brian Kohberger is innocent or did not do this, because there are things that happen in every case that are happening in this case in a form or fashion, which allows people to continue down that rabbit hole. Now, how do I look at Brian Kohberger? How do I look at this case? I look at him as somebody who's cloaked in the presumption of innocence. The state has not proven their case in court beyond a reasonable doubt. Therefore, he is innocent and presumed innocent, even though there's enough evidence to hold him without bail right now. He's enough of a danger to the community. It's a serious enough offense. All of those things apply to why he is sitting in prison awaiting trial. But I will say his defense is fighting vigorously. They're defending him zealously, and they're continuing to do so in the set of motions and replies we're going to read today about the fact that it seems like they think there is more to this IgG DNA evidence than meets the eye. So much so to the level that they want their defense experts to be able to look at it in a broader sense than may currently be allowed by the court. So let's take a look at this first motion together, okay? And if it's hard to read on the screen, have no fear. I am going to read it for you. So this first one is a motion to allow certain experts and investigators protected access to view the IgG materials. Comes now, Brian C. Kohberger, by and through his attorneys, and hereby moves this court for an order allowing certain experts and investigators protected access to view IgG materials. Counsel for Mr. Kohberger has reviewed the materials currently available under the court's sealed order for disclosure of IgG information and protective order filed with the court on 12/29/23, and requests the court to include additional members of the defense team to access the materials. So the materials they already have, basically they're saying, we need help from our experts. You already know these experts. We've hired them. They've testified. They have the right background, and they will aid in this defense. Mr. Kohberger specifically requests the current protective order to expand and allow defense experts Dr. Lee Larkin, Bicca Barlow, and Stephen Mercer access to the materials. I believe these are the same experts that testified before the court obviously listened to them enough to allow some of this IgG information to even go to the defense. Further, Mr. Kohberger requests that the criminal investigators that are part of the defense team be allowed to have access to the materials as well. Expanding the current protective order to include additional members of the defense team and experts includes each additional person subject to the restrictions in the protective order. So they won't have unfettered access. They won't be able to go talk about it. They will be subject to the same protective order that Kohberger and his team are subject to. This request is grounded in Mr. Kohberger's Sixth Amendment right. The reason defense attorneys always throw stuff like this in there is they want the court to know how serious this is. This is about the defendant's Sixth Amendment right to a fair trial and assistance of counsel, and counsel's ongoing duty to investigate the case brought against Mr. Kohberger. Access to these materials is necessary to investigate how and when Mr. Kohberger was identified as a subject. Okay? So they want them to have access to aid in his defense. It's necessary, it's reasonable, and they will be subject to the same protective order, so they won't, do anything crazy with this information. Second motion. Motion requesting clarification of the sealed order for disclosure of IGG information and protective order. Kohberger comes now, by and through his undersigned counsel, and hereby moves the court for an order clarifying the language contained in the sealed order for disclosure of IGG information and protective order filed with the court on December 29, 2023. The court's sealed order states that no individual on the family tree may be contacted by the defense or any agent of the defense without prior authorization from the court after a showing as to why such contact is necessary and material to the preparation of the defense. Sounds like that's exactly what they're doing. They're trying to ask the court, what does this actually mean? The defense, as part of the necessary work, has previously identified family members and work is being conducted. Meaning maybe it's not even from the IGG information, but we found family members from other ways. The defense does not expect to use the protected material to identify people to contact without further order of the court. However, the defense needs to continue its investigation with witnesses and resources generated from sources outside of the protected materials without worry. The plain language of the protective order could be interpreted to prevent that work. The defense seeks clarification of the specific language of the protective order. So what does this mean? Well, certain things you get, it's kind of like, to flip it on the prosecution side or the law enforcement side, fruit of the poisonous tree. We got some information from a way that, was illegal search, and we found a computer that had documents on it. Well, if there was a legal way that we already knew about those documents or already had those documents or could have gotten those documents, we should still be allowed to use them. So here, if we already knew about a family member, if we already knew about an argument, if we already knew we were going to go a certain way, we should still be able to do that, even though this family member or this information is included in the protected IGG DNA information or materials. It's reasonable. The court should allow it. Maybe they knew they wanted to talk to Jane Doe, and then Jane Doe pops up in the IGG information. It's like, but judge, we already knew that. We shouldn't be precluded from using it because we already knew it in a way that was not covered by this protective order. They want to make sure that's okay. They want to make sure everything's above board. I respect them asking, as opposed to, they're asking for permission as opposed to forgiveness, because they could do it a different way. All right, here is the state's response to both of those motions. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully submits the following responses to defendant's motion to allow certain experts and investigators protected access to view the IGG materials filed on February 1st, and defendant's motion requesting clarification of the sealed order for disclosure of IGG information and protective order filed on February 8th. Regarding the expansion of the protective order to include Dr. Leah Larkin, Becca Barlow, and Steve Mercer, the state does not object. Hey, I haven't read this, by the way. I read the defense's motion. I hadn't read the state's reply till right now with you guys. That's reasonable. I said the judge should allow it. Guess what? The judge is definitely going to allow it if the state is not even objecting. But there's 3 more pages, so I assume they're going to have a problem with this. Regarding the expansion of the protection order to include unnamed criminal investigators' unfettered access to the IGG materials, the state objects. At a minimum, individuals who will have access to any of the IGG materials should be named. Further, the defense has failed to make an adequate showing as to why such individuals need the information for preparation of the defense. The defendant states that the information is requested to investigate how and when Mr. Kohberger was identified as a suspect. This information can only be obtained from the TUI letter from the FBI to the state dated November 28, 2023. The state objects to the balance of the IGG information being provided to the criminal investigators for the reasons articulated by the court in its protective order. So there's some stuff we don't know about, some stuff we haven't read or seen. So it's hard to get some context about what they're arguing about because some of it is in the court's order that is sealed. So basically, they're objecting to unfettered access for investigators to be able to run on certain information contained in the IgG, saying they got it a different way, all just to find how and when Mr. Kohberger was identified as a suspect. Is the state scared of the defense finding out how and when Kohberger was identified as a suspect? I don't know. Do they just, and I respect this, right? Because we talk about, we don't want to give unfettered access to the government or to anybody, to anything that we don't have to. We don't want the government to overreach. We don't want the state to overreach, and they don't want the defense investigators to overreach. So I understand pumping the brakes on some stuff. Regarding the defense's motion requesting clarification of the sealed order for disclosure of IgG information and protective order, the defense experts or investigators should not be allowed to use the protected materials to identify individuals or witnesses to contact without prior authorization from the court and after showing why such contact is necessary for the preparation of the defense. So this is the important line. They should not be allowed to use the protected materials. So again, if they get it another way, from some other reason, from some other witness, or they identify these people in something that has nothing to do with the protected materials, seems like the state's not objecting to that. But if they connected a single dot, or if any step in the process included use of the protected materials to identify those individuals, they should absolutely not be allowed to do that without authorization from the court. And I 100% agree with the state, but I think the defense would also agree at this point. This would not prohibit the defense from contacting potential witnesses learned through sources outside the protected information. Kumbaya. Seems like we're all on the same page. The state respectfully submits that the appropriate course of action would be for the court to amend the sealed order for disclosure of IgG information and protection order to allow Dr. Leah Barkin, Becca Barlow, and Steve Mercer access to the IgG materials disclosed to the defense. The criminal investigators seeking access to the information should be named in the order, and those investigators should only be allowed to access the November 28th, 2023 letter provided to the defense. I don't think we've seen that unless I'm just drawing a blank. The state also requests the following language for an amended protective order. Okay, so the state's basically saying it can't just be anybody the defense deems necessary that they should have access to this, but instead somebody specifically set out and allowed by the court and named in the protective order that they can look at this stuff for very specific reasons, and they're subject to the same protective order as anybody else. So if they violate that court order, they can be held in contempt and sanctioned. The court orders that only defense counsel Ann Taylor, Jay Logston, and Alyssa Masseth, defendant Brian Kohberger, and Dr. Leah Barkin, Becca Barlow, and Stephen Mercer may view the materials provided. Insert names of the criminal investigators may view only the November 28, 2023 letter contained within the materials. Any further dissemination of the materials or the information contained within the materials must first be approved by the court after an adequate showing by the defense as to why such information is necessary and material to the preparation of the defense. Additionally, no individual learned solely through the review of the materials shall be contacted by the defense or any agent of the defense without prior authorization from the court after an adequate showing as to why such contact is necessary and material to the preparation of the defense. I don't see why the defense would have any problem with that. I think everybody's on the same page about what we should do and what the court should do with this information. It should still be protected. If they get information outside of the protected materials, they should be able to run with it, but they should not be able to use the protected materials in a way the court has already said no, unless they get authorization from the court, which is how it always is. So to me, these motions are a nothing burger. The defense, besides the fact that the defense wants their experts to be able to use this information, makes total sense. They used the experts to even get this information. The state doesn't have an objection to that. I don't see a problem with it. I don't see how the defense would have a problem with the language. So the state doesn't really seem scared to have the experts look at this. To me, this exudes confidence on the part of the state. And again, that's one of the things with this case. I'm about to do, in a couple weeks probably, the snapshot of this case. And one of the things I'm going to mention is the defense keeps insinuating there are major holes and connections not being made, and the state keeps exuding confidence. Wait till you see what we've got. There's more. And I believe there is, but we haven't seen it yet. So let me know. Do you think the state's scared of what the defense is going to find in this DNA, IgG information? Or do you think the state is exuding confidence at this point and ready to go to trial, maybe as soon as this summer, but probably next summer? All right. I appreciate you guys joining me. Hit that like button. Make sure you comment, subscribe, hit the reminder bell, because you really never know this week when the videos are going to pop. Can't wait to hang with you live again. But for now, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.